what Finley Davies is going to have is a compliance series of webinars. I thought today we would focus on a few areas that I see come up a lot with clients. Just to give you a little more background about myself, I've been with Finley Davies for a while now, and as Lisa mentioned, I help lead up our technical resources group. In a prior life, I was a shareholder at an international labor and employment law boutique, and there I did a lot of speaking and training for clients. And so these topics are the topics that came up, unfortunately, all too often, compliance issues with respect to these topics. So for some of you, this may be kind of ERISA 101. For others of you, these are areas that you may not have thought about as much as you should as an employee benefits professional. Also, we're focused on ERISA. So there may be some of you who are, in the governmental entity area, whether you're with a township or a county, a public school, public university, or a church plan. If you're in that group of employers, some of this ERISA stuff may not apply to you. If you have a question as to whether or not this ERISA stuff applies to you, give me a phone call and we can talk about exactly how ERISA applies or doesn't apply and which requirements you have with respect to those provisions in your plans. So with that, I'm going to start with the first, really the three topics we're going to focus on today. And those topics are plan documents and summary plan descriptions. We're going to talk about what ERISA says about those requirements. We're going to talk about what is and what is not an ERISA plan and what is and what is not an ERISA summary plan description. Also during that discussion, we'll talk about cafeteria plans and some kind of best practices for you if you're relying on vendors, insurance carriers, brokers on documents. The next piece is electronic communications. Again, we're in 2016. It seems that everybody has access to electronic media. I have an 11-year-old son, and it makes me nervous when I see his friends come over with their own personal iPhones. So, we see that out in the public that everybody has an iPhone, a laptop, a tablet. The IRS and the DOL, they don't really live in 2016 when it comes to technology. They maybe live in 1998 or 2002. So there are very specific requirements that you need to meet if you're using electronic media to distribute participant communications or to get participant elections with respect to benefit plans. So we'll talk about those requirements in a little bit of detail. And finally, when the inevitable happens, you may be looking at correcting problems. And fortunately, the IRS and DOL, they know and understand and acknowledge that administering benefit plans are challenging. Things happen, whether somebody's, doing everything they can and something slips through the cracks, or somebody may not really understand what they're doing and misses something. So we'll talk about three key correction programs that we have to look to if we have a problem with respect to our benefit plan. So with that, we'll start with ERISA requirements on plans and summary plan descriptions. So these are kind of basic slides. This is a basic slide, the basic requirements that ERISA says we have with respect to plan documents and summary plan descriptions. Obviously, both of them, the plan and the summary plan description, must contain specific information. We'll talk about some of those specific requirements. Plan documents, the general language is that they must be maintained and distributed to participants and beneficiaries upon request. Whenever you see benefit litigation, the first thing that a plaintiff's attorney is going to ask for is a copy of the plan document and the summary plan description. If you don't have that plan document readily available, that summary plan description readily available, you're going to have some issues. Even generally, when you have a plan participant ask for a copy of the plan or a copy of the summary plan description, you have a specific requirement to provide it to them. So, we have to have that plan document in place. Summary plan description, same concept, has to have a whole host of specific information in the document, and that must be proactively distributed to plan participants. So first we're going to talk about the plan document requirements, and this is what ERISA says. I'm not going to read the quote, but the key point here is that ERISA says an ERISA plan must be maintained pursuant to a written instrument. And that gets into my note here. Just because you don't have a plan document doesn't mean you don't have an ERISA plan. You have a compliance issue. And the easy, most common example that I use with respect to ERISA compliance plan documents is severance. Some employers, and some of you may be surprised to know that a severance plan may or may not be an ERISA plan. If you Google Fort Halifax case, there's a famous case that it involves this Fort Halifax entity, and it's the case that tells you whether or not a severance plan is subject to ERISA. And the magic phrase is ongoing administrative scheme. So if you've got a benefit plan that has an ongoing administrative scheme, you will be subject to ERISA. So in the severance context, I give this example. If you've got a severance plan and basically it says that if somebody is terminated, they get 2 weeks of salary and that's it, probably not an ERISA plan. I feel pretty confident saying it's not an ERISA plan because there's no ongoing administrative scheme. You just figure out what that amount is, you write a check, the end. Now, if you have a severance plan that says, well, a certain class of employees get severance benefits, there's certain discretion with respect to the plan administrator, which would probably be the company. There's continued medical benefits, there's outplacement benefits, there's all kinds of other stuff. Now you're starting to get yourself into the ERISA world. And if you're in the ERISA world, you have a requirement to have an ERISA plan document. You also have to have a summary plan description, also have to do Form 5500s, which we'll talk about later. So I've seen employers try to, close their eyes and turn their backs to ERISA compliance because they don't want to deal with it. They say, well, we don't want to deal with it, it's just a severance plan, who cares? But, the conservative route would be, if you've got a severance plan that has a few bells and whistles, would be to have the plan document, to have the summary plan description, and then deal with the Form 5500 if you have enough participants that would require you to file the Form 5500. So, again, the fact that you may not have a plan document, that doesn't mean you don't have an ERISA plan. So, severance is my example on that one. So, what does ERISA say that you have to have in the plan? I'm not going to, spend a whole lot of time on this. These are just kind of basic requirements. Who's the named fiduciary? What are the fiduciary duties that that named fiduciary has? One thing I'm always focused on is delegations of fiduciary duties. That's something that sometimes gets missed in plan documents. You might have generally the employer be the fiduciary. Well, the employer may delegate certain responsibilities to the benefits department, to an individual, to an outside person. If there's a delegation of fiduciary duties, you need to consider having that as part of the plan, or at the very least having some kind of written policies, procedures outside that refer back to the plan on this delegation. Plan funding, plan payments, claims procedure. Claims procedure is very important under ERISA for a few reasons. I'm going to talk about that in a little more detail later. And then amendment and termination. You always want to make sure you reserve the right to amend and terminate your plans. A few considerations. One is using plan assets to pay plan expenses. Most common area is 401k plans. There's two different expenses. You've got plan expenses and then you got plan sponsor expenses. And there's very specific rules on how you can use plan assets to pay for plan expenses. If permissible, you just want to make sure that your plan document says that. A next consideration is incorporation of summary plan descriptions. I'm going to talk about wrap plan documents later on, but if you have a basic plan document that may not have all the details in it, but you incorporate the terms of a summary plan description to fill in the holes, you want to make sure your plan document properly addresses that. And if you do have that incorporation, you have to make sure that any changes are properly dealt with in those summary plan descriptions. And then the final one is the right to interpret. And I don't want to get all legal on you, but there's a famous case, it's a Firestone case, where it talked about the right to interpret. What rights does a plan administrator have to interpret the terms of a plan? You want to have that language in there because it provides you as a plan sponsor, puts you in a better position down the road in the event of some sort of risk litigation. Because if you reserve that right and you make a reasonable interpretation and the person bringing the claim has gone through all the hoops that they need to do to bring their claim, the court will generally defer to that interpretation. You just want to make sure it's written in the plan document. Okay, so after talking about plan documents, it's important to talk about cafeteria plans. Cafeteria plans, 125 plans, flex plans, you call them, various different things. This is the vehicle that allows for folks to pay premiums on a pre-tax basis, allows them to make flexible spending account contributions. This is all about the pre-tax stuff. Comes under Section 125 of the Code. Now, back about, I think it was 8-9 years ago now, we got proposed regulations on the cafeteria plans. I think I actually wrote an article about it 8 years ago saying that employers really need to rush to get their documents in place because we'll be seeing final regulations soon. We still haven't seen those final regulations. That being said, the proposed regulations for cafeteria plans specifically say you must have a written plan document. So if you've got, pre-tax premiums, if you've got flexible spending account, if you've got anything else going pre-tax, need to make sure that you have a properly written cafeteria plan. The next bullet point is common sense, and I'll talk about it a couple times, but if you have a plan document, you have to administer your plan in accordance with the terms of the plan document. So plan document and plan operation need to be in sync. If you're going to make changes, make sure you properly amend your plan. If you have any concerns about, the historical administration versus plan documents, you're going to want to reach out to your advisor, whether it's your attorney, consultant, broker, whoever. Reach out to them and take a look at the plan, take a look at the operation, and make sure things are lining up. And then the last bullet point is something I don't think employers think about a whole lot, and plan sponsors think about a whole lot. Mid-year election changes specifically must be stated in the plan document. So what am I talking about here? Well, when we're talking about medical plans, what happens if I have a change in status? Can I make an election change? I think benefit professionals know and understand that cafeteria plans allow election changes mid-year for certain events, change in status, cost changes, significant benefit changes, things like that. Well, taking a step back, the general rule under cafeteria plans are that elections are irrevocable. You don't have to allow these sort of election changes. Now, I'm putting aside HIPAA special enrollment rights because there are some federal regulations on election changes, but the more typical, change in status events, you don't have to provide them. They're optional. If you do provide them, they need to be in your plan document. So every once in a while, I see this go one of two directions. It's one, employer didn't want to have all these election changes, but the plan document was written by somebody who just assumed that they were going to be in there, because most employers have them, and you have an issue because the operation doesn't line up with the actual plan document. Or it can go the other way around where, they're all in there, they didn't want to have them. So you just want to make sure that the plan document clearly has what you want when it comes from election changes. All right, so we're shifting gears. We're moving from plan documents to summary plan descriptions. And here in the summary plan description discussion, I want to really focus on 4 areas. One is understandability. Understandability is a specific requirement for our summary plan descriptions. I'll talk about how it's much easier said than done, but we'll talk about the understandability requirement. We'll talk about the content requirements. What do we specifically have to have in our summary plan descriptions? I'll highlight the key ones. There's lots of things we should have in there, but I'll focus on the key ones. Third, I'll talk about wrap plan documents and SPDs. This is valuable. If you more for a welfare benefit plan design, but this is that area. If you've got a bunch of insurance booklets, certificates, and you may not have a properly written plan document, you may not have a properly written summary plan description, a wrap plan document is a good vehicle to make sure that you're in proper compliance with ERISA. And then we'll talk real quick about the distribution requirements for summary plan descriptions. All right, so first we're going to talk about understandability. And that first bullet, that's the language from the guidance. That's regulatory language on what an SPD needs to look like. So what do we have here? Well, we have this understandability requirement, and the understandability requirement is not, can it be understood by the ERISA attorney, can it be understood by the welfare benefit plan manager, the pension plan manager, the HR professional, by the average plan participant. So we're talking about, the worker on the line, we're talking about the server, we're talking about the retail worker, we're talking about, you know, the average American who doesn't look at ERISA and code on a daily basis. Can they understand it? But then we get to the next part of it that talks about it being sufficiently accurate and comprehensive. So we've got this kind of scale, and part of it's a science, part of it's an art. We need to be understandable, but we need to be accurate and comprehensive. So, you know, how do we get there? I'll talk a little more about it in another slide or two, but, you know, the concepts I always start with is we want to be clear, complete, we want to be understandable, and we want to think about examples. I'll talk about examples in a second. But again, we're weighing this understandability versus comprehensive, sliding scale. My recommendation is that, yeah, understandability is extremely important, but we've got to make sure we're accurate. We've got to make sure we're comprehensive. So I'll give you some suggestions on how to deal with that in a minute. But, you know, if we've got to go one way or the other, I say let's put a little more information in there, maybe explain it, you know, with an example or something, but, you know, make sure we're comprehensive, make sure we're accurate, and then we can deal with the understandability of it. So these are the practical tips that I kind of hinted that I would get to in the previous slide. You know, when we're dealing with understandability, what things do we need to keep in the back of our mind? Well, first, again, I'm an ERISA attorney. I can sit in a room with benefit professionals and we speak our own language. You know, I know what the view is of ERISA attorneys. You know, they speak code, they speak ERISA, they don't know how to speak English. And, you know, I can talk the talk, but, you know, we need to speak English when we're talking to our plan participants. So, you know, avoid using the jargon that you use when you're, you know, talking about the code. You know, abbreviations you need to be careful about, acronyms you need to be careful about. And that gets me to my second bullet. If you're going to use kind of those magic terms, because sometimes you want to, you know, use normal retirement age or something like that, some kind of term of art, I suggest using a glossary of definitions. Use that term in the body of the summary plan description and give folks the heads up when they see, you know, normal retirement age, capital N, capital R, capital A, that if they see those capitalized terms, to flip back to the glossary and then they can get a definition, which will be written in plain English so folks know and understand. The next idea is that, you know, the DOL and the IRS and some of the other agencies, they'll issue model sample language that you can use for both of your plan documents and your summary plan descriptions. For summary plan descriptions, you know, if the DOL or some other government entity has blessed that language, I feel pretty safe advising clients to use that language in their summary plan description. So, you know, you might want to tweak it a little bit, but I generally encourage you to use that model language. I mentioned this before, examples. I really like using examples when we're talking about complex benefits. So, you know, if we've got a defined benefit pension plan that has a final average pay formula combined with a cash balance benefit, and there's a freeze, and there's a planned merger, you know, I can create some kind of crazy situation, but, you know, we've been there, and we know how these benefits can get complicated. My recommendation is to use some examples. So, you know, take Joe Smith, who retires on January 1, 2016 at age 67 with 35 years of service. And, you know, based on those facts, lay out what Joe Smith's benefit would be, because, you know, Jane Doe may look at the summary plan description and say, oh, you know, if I work that many years and I've been here for so long and I retire at this age, yeah, I understand what my benefit is. So examples, I think, are very good to use. Simple vocabulary, plain English, like I said before, if we can tone it down, let's tone it down. Again, we want to be careful. We don't want to tone it down too far so that, you know, if we do that, we can create understandability issues or, you know, accuracy issues, so be careful on that. And then the final one is using separate SPDs for different groups who have different benefits. So, you know, an example of this is an employer may have a life and AD&D benefit. And it may say for, you know, this, you know, for hourly folks, they get $10,000 of benefit. For salary folks, they get $30,000. Then they have Union 1, Union 2, Union 3, Union 4, and they all get different benefits. Do you really want to have one SPD that spells out all the different benefits for all the different groups so that everybody can see what those are? Or do you want to have separate SPDs? And the separate SPDs don't necessarily have to be completely different summary plan descriptions. One strategy that I've used for clients is to have a kind of a base summary plan description that lays out, the basic terms that applies to everybody, and then have supplement 1, supplement 2, just various supplements that fill in the differences between the different groups. So, using one SPD when you've got a bunch of different benefits for different folks, you may want to consider separate SPDs or kind of using that base SPD with supplement strategy. All right, so SPD provisions, what do you need to have in there? I'm not going to spend more than a couple seconds on this one. There's specific plan identifying information that needs to be in there, information about the plan, information, well, this second line should say employer, not employee, information about administration, plan year, collective bargaining status. So that's just boilerplate stuff that every SPD needs to have. These are more meaty things. Description of eligibility and benefit provisions. This is kind of an obvious one, but sometimes we miss bits and pieces here. For example, eligibility. What happens if somebody goes on a leave of absence? Does your summary plan description and, frankly, your plan document, are they clear about continued eligibility during leave situations? So just making sure eligibility is correctly dealt with. Benefit provisions, if it's a retirement plan, make sure the formula is in there. The next one is cost sharing for health coverage, so laying out premiums, deductibles, co-pays, co-insurance, all that good stuff. Group health plans, they have a number of required disclosures. There's the alphabet soup of HIPAA, COBRA, PPACA, healthcare reform. There's all kinds of disclosures that we need to have. Next one, claims procedure. I touched on this a minute ago. So we need to make sure that folks know and understand what the claims procedure is. We have to make sure it's accurate. For health plans, you may have internal review and external review. But when I talk about the claims procedure, I also bundle in the statement of ERISA rights, making sure that folks know and understand what their ERISA rights are. Because when you got the claims procedure, you got the ERISA rights. I talked before about the right to interpret. These are what I kind of call weapons for litigation. Again, down the road, if somebody wants to bring an ERISA benefit claim, ERISA litigation, if it's done the right way from the employer's perspective, it's one that really focuses on the file, because you have a plan document that lays out what the claims procedure is. You have the summary plan description that lays out what the claims procedure is. You lay out what the ERISA rights are. If the individual does not follow those claims procedure provisions, they don't follow their ERISA rights, you might have 90 days to make an appeal. Say they wait, 200 days. Once they miss one of those requirements, the judge is going to throw the ERISA case out the door, because a plan participant has responsibility to follow this claims procedure. And that's why being clear what the claims procedure is, what ERISA rights are in the summary plan description is very, very important. ERISA rights, you can actually pull that language from some DOL model language. It's pretty boilerplate. Just some other thoughts on what should be included in the summary plan description. Employer's right to amend and terminate the plan. You want employees to know and understand that they're not being guaranteed their benefits forever. So just make sure it's clear in there. The second one, it depends on the court. It depends on the judge. I've always put it in there. Any employee benefits attorney's going to put it in there, basically saying that in the event of a conflict between the terms of the SPD and the plan document, the terms of the plan control. Some judges, some courts will say, well, as far as the plan participants are concerned, the SPD rules, so we're just going to say the SPD terms apply. I still put it in there, kind of, just a little more protective language in there. Interpretation, I talked about that before. Description of circumstances causing loss or denial of plan benefits. I talked about being clear about what it takes to become eligible in the plan, but be clear about when you lose benefits under the plan. And that kind of goes back to that idea of what happens in a leave situation. some employers may say, well, if somebody's out on medical leave, we'll provide 6 months of continued benefits. Or if somebody, if we've got you can talk about strikes, you can talk about lockouts, you can talk about, unpaid leaves that are approved. You just want to be clear as to how benefits continue during the leave situation, when they end, and then there's also the additional consideration of COBRA. When does COBRA actually start? So just be clear about eligibility and loss of benefit. Obviously, you need to talk about plan contributions and funding as well. All right, so we talked about plan documents, talked about SPDs. So let's talk about what I'd say 90–95% of the time is not a summary plan description, not a plan document. So, you're a small employer, you go to your broker, and you want health, dental, vision, life insurance benefits. And, the broker, goes out to market, we decide who our carrier is going to be, and we get these beautiful benefit booklets that tell everybody what their benefits are. You also have your contract with your vendor. You say, okay, well, I got everything I need, we'll just move on. Well, let me tell you that in the great majority of cases, those benefit booklets, those certificates, whatever they're called, in most cases, those are not summary plan descriptions. They do not meet all the requirements of a summary plan description, and you have a compliance issue. You also don't have a plan document. That vendor contract, those booklets, that policy, that's not going to be your plan document. So just want to be clear that if you're relying on these documents, I'd advise you to have them critically analyzed to see whether or not they are summary plan descriptions. Probably not. If even arguably they are, there's probably some holes in those documents. It probably doesn't have clear eligibility provisions, depending on what the benefit is. May not properly deal with Affordable Care Act, may not properly deal with some of the ERISA requirements. So, again, if that's what you're relying on, I would recommend talking to your professional, or I would recommend considering a wrap plan document. A wrap plan document is a vehicle that we use when you are relying on these booklets and certificates and they don't meet summary plan description requirements and or plan document requirements. The reason we call them a wrap plan document is that effectively the document has all the boilerplate legal stuff you need to have. It has the elective provisions that you have with respect to your benefit plan, and then it defers out to those other documents. So we say it wraps around those other documents that you've received, and this really is a welfare benefit plan issue. I should have been clear on that. So this document has all the ERISA stuff. It incorporates all the certificates, and together you can have that be a wrap plan document. You can have it be a wrap plan summary plan description, or you can have it serve both functions and be a wrap plan and summary plan description. To make it life a little easier for you, when you do that wrap plan document, typically you have the actual base document have all that legal boilerplate material, all the required legal requirements, and then at the end you use exhibits, supplements to refer out specifically to those booklets. So, you might have a laundry list of those booklets that Aetna, MMO, Blue Cross Blue Shield has provided you. We'll spell out who the claims administrator is, things like that. And it also offers you the opportunity to have a single welfare benefit plan as opposed to a number of welfare benefit plans. It can make life much easier for you when it comes to Form 5500 reporting, which we'll talk about later. So, if you don't have proper ERISA documents, well, the question becomes, how many ERISA plans do you have? Do you have a health plan, dental plan, vision plan, life plan, AD&D plan, LTD plan? There's 6 plans right there. Using a wrap plan document, you may consider, and often I recommend, you have all those 6 benefits be part of one welfare benefit plan, have a single plan document, have a single summary plan description for those benefits, and then you have one 5500 filing as opposed to 6. So another reason why this vehicle, a wrap plan document, is something to consider. Real quick, distribution of summary plan descriptions. If you have a new SPD, you have to get it out within, or if you have a new plan, you have to get it out within 120 days. For new participants, you've got 90 days from when they become covered under the plan. So you're not just sending them out to all your employees. Once they become covered under the plan, 90 days. Plan amendments, so you got 120 days after the end of the year which the change is adopted. So if you made changes during 2015, you've got effectively until some point in July of 2016 to get those amendments out. And then new SPDs. This sometimes gets missed. Every once in a while, a client will say, here's our summary plan description, and I'll look at it, and it's 15 years old. The general rule is that if you made any changes to your summary plan description, you need to send out a updated one every 5 years. If you haven't made any changes, it's 10, but there's very few of us who deal with plans that haven't been changed over the course of 5 years. All right, so we are going to shift gears here and talk about using electronic media for benefit plan communications. And this comes in two flavors. First, we're going to talk about the IRS rules, and then we'll talk about the Department of Labor rules because they're different, although there's some overlapping concepts. So first, we've got the Treasury regulations. These are our IRS rules, and here we're focused on applicable notices and elections. And in a second, I'll talk about what an applicable notice is, but you'll see the second bullet point. What the regulations basically say is that, okay, this applies to anything that falls under the IRS rules, anything that falls under the DOL, PBGC rules, that's not covered under these rules. So I'll talk about those rules in a few minutes. All right, so what is an applicable notice? This is what I said it applies to. Well, basically anything that falls under the code going to a recipient under a retirement plan, a welfare plan, or an IRA. So I give you a few examples. There's lots of other things that this would fall under, but again, here we're focused on code-required communications, anything that would fall under the code or something that we'd have Treasury regulations on. All right, so these are the basic requirements for using electronic media under the IRS rules. There's a few, key concepts we need to keep in mind. First is understandability. If you're using electronic media, it has to be just as understandable as if you're using paper. Now, if you're, sending things that, the documents in a PDF format, pretty clear. But if you're tweaking it, if it's an online system, you need to make sure it's just as understandable. Second, when you use that electronic media, you have to note the significance of the information that's being provided. You also have to provide instructions necessary to access the electronic notice, and again, we got this understandability concept. Understandability is a common theme when you're talking about plan participant communications. Again, if you're using electronic media, that understandability requirement continues to apply. And then the final key item here is that there has to be some kind of system to maintain this electronic media, whether it's the electronic distribution of something, whether it's an electronic election. Because if this electronic method, if you can't maintain documents, if you can't reproduce them down the road, and you have some kind of litigation, well, what are you going to do? There's going to be an issue that you're going to have with respect to the legal effect, the validity, the enforceability of that document. So there has to be a system in place to make sure that we can retain those documents and retain records showing that they were properly distributed. So what are the approved methods according to the IRS for electronic distribution? Well, there's two. One is the consumer consent method, and it's just what it sounds like. It's consent. I'm going to talk about this in a little more detail when I talk about the DOL rules because they're very similar. The other method is the alternative method. This is, it's a little fuzzy. The general rule is that, to follow this method is that, at the time you provide it electronically, you have to tell folks that they can get a paper version of it at no cost, which is fine. But it's the second one that's a little fuzzy, and it basically requires that the recipient is effectively able to access the electronic medium. Well, there's not a whole lot of guidance on this one. It's looser than the DOL rule that I'll talk about in a minute, but it's loose. So, the common question I get is, well, can I use a kiosk? We have a shop floor. Can we put a kiosk in, the break room and use electronic media for that? And my answer is, yeah, for the IRS stuff, not the DOL stuff, and I'll talk about the DOL stuff in a few minutes. So kiosk may be okay. Sending to the last known email address, is that good enough? I would say no under the IRS rules. So if you're using electronic media under the IRS rules, you need to either get consent or feel comfortable under the alternative method. Special rules when you have elections. The elections are, it's kind of the same as the applicable notice requirements, but the big thing here is that, one, it has to be designed so that only the individual has access. So their username and password, that's usually the way you go. The second one is that you need to have the system set up so that the individual can review their elections. So, in Finley Davies, when you want to enroll in the health plan, you go online and you fill in your information. Yes, I want to elect health plan 1. Yes, I want to elect dental 2. No, I don't need vision. Yes, I want to enroll in the FSA. Click accept. What happens is you get another screenshot saying, okay, this is what you have elected. Please confirm that these are your elections. So it's kind of that second review that you need to have. And then, paper needs to always be available to folks. So if you're using it for elections, additional considerations. Now we move on to the Department of Labor. The Department of Labor has its rules. There's safe harbors. So if you follow them, you're okay. It's not the only way to satisfy the ERISA disclosure requirements, but I caution employers to go any further than these because, the last thing you want is the Department of Labor fighting with you over whether or not this electronic method that you've chosen that are not safe harbor, whether it's appropriate. So it covers communications from plans to employees, participants, beneficiaries. These are the documents. So when you looked at the IRS rules and it caveated all the DOL and PBGC notices, well, this is the regulation, these are the documents, so your summary plan descriptions, your 404 communications, quadro notices, COBRA notices. You can use electronic media, you just need to satisfy the DOL rules. All right, so here are the DOL safe harbor general rules. The first one, obviously, you have to have a system set so that it results in actual receipt of the information. Second, confidentiality. We kind of noted that in the IRS stuff. It has to be set up so it's confidential so that personal information doesn't get leaked. It needs to meet the ERISA requirements on content, style, format. So, it goes back to understandability, meeting the requirements of what the code or what ERISA says. Similar to the IRS rules, the significance of the communication must be spelled out if it's not clear. And then paper. Paper is always something that needs to be provided if somebody asks for it. And you have to tell folks that they can get paper if they want that. So here we have two groups. First, on the DOL side of things, you have what we call integral employees. So what does that mean? Well, the key concept here is that access to electronic media is integral to the job duties of that individual. So, I'm a consultant, attorney. Unfortunately for me, I sit in front of a computer screen 8 to 10 hours a day most days. For me, having a computer, having access to electronic media is integral to my job duties. So my employer, Finley Davies can issue plan communications under the DOL rules to me. It does include employees who work from home, assuming that they're tied into your system. So if you've got, flex scheduling, or if you have folks who allow work from home and you give them a laptop and they can log into the system, it'll cover them too. This is a little different from what I talked about under the IRS rules. It doesn't include folks whose only access would be using a kiosk. If you've got a shop floor, under the IRS rules, you can put a kiosk in the corner of the break room and they can access their IRS stuff. But if they, I hear somebody, if you don't have your phone on mute, please put it on mute because it sounds like somebody may be getting through. Anyways, so under the DOL rules, if you have somebody who works on the shop floor and you just post things on, tell them, oh, you can get your DOL notices, you can get your summary plan description on the kiosk, that doesn't work because that kiosk is an integral part of their job function. So big difference in the integral employee versus the effectively able standard of the IRS rules. A second group of individuals is consent. So under the consent employees, and this is similar to the IRS rules, we have specific requirements to be consent. You have to get that affirmative consent. Prior to providing consent, you've got to give these individuals a notice, and the notice will specifically lay out what the documents that are going to be provided electronically, what they're going to be, the fact that they can withdraw their consent at any time, how to do it. Again, they can always request paper. It'll talk about the software hardware requirements to access and retain the documents. And that consent must demonstrate the access to, the ability to access that communication. So in the IRS world, we have the alternative method, consent. In the DOL world, we have consent or integral. If I'll focus on the DOL side of things because this is usually where it comes up more, is the DOL side of things. How can I use electronic media for our summary plan descriptions to all of our employees? If you don't have somebody who's an integral employee, that electronic media is integral to their job duty, or a consent employee, they've affirmatively consented to you using electronic media, if you don't have that person falling into one of those two groups, you need to be sending them paper. Just, throwing a bunch of copies in the break room or having a kiosk or just posting it online, that's not good enough for summary plan descriptions and all the other DOL required disclosures. So that's why I wanted to spend a little time in electronic media because, sometimes employers just miss this concept. Now, I do know that IRS and DOL have, asked for comments about, how to, for them get into the 21st century, get into, 2016, 17, whenever they decide to issue new regulations on this, because again, technology changes, access to technology changes. So down the road, we may see some additional guidance that softens this. Okay, so we've talked about plan documents, we've talked about summary plan descriptions, we've talked about electronic media. Like I said before, things happen. We make mistakes. Sometimes it's just, things slip through the cracks. Like I said, benefit plans, they're difficult, they're hard to administer, they're complicated. Sometimes we have to do things in a rush. Sometimes we have to answer questions quickly. We have to send things out. Thankfully, the IRS and DOL have correction programs, and I'm focusing on 3 key correction programs today. The first one I want to talk about is EPCRS. The focus there is tax qualified plans and operating them properly, documenting them properly. I'm going to talk about what options we have under EPCRS, what considerations we have on EPCRS, and I'm also going to go through kind of the top 10 list of common failures that we see that we can use EPCRS for. Second one is the Voluntary Fiduciary Correction Program. This is focused solely on fiduciary issues. We have this guidance. It's somewhat narrow, but it covers some areas where, employers often have issues. And then the last one is the Delinquent Filer Program. This is our Form 5500s. I talked about it before. Not all of you are subject to ERISA, so not all of you have to deal with Form 5500s. For those of you who do, we need to know and understand what plans we have to file for. Tax qualified plans, that's typically taken care of pretty well. It's the welfare plans that become problematic and we see issues on. So we'll talk about that. All right, so first we're going to talk about EPCRS. Well, what is EPCRS? EPCRS is a program. It generally comes in the form of a revenue procedure. The most current version is 2013-12. And it provides us information on how we can correct tax qualified plan failures. It's interesting for me because in my prior life as an attorney, I worked with another attorney at my prior firm who actually wrote a prior version of EPCRS. And so to get the IRS's perspective on EPCRS is very interesting. We've generally seen the program expanded. We've also seen the program be more formal in the sense that we have more forms to work with, more guidance on how to correct things. So what are we dealing with when we have EPCRS? Well, we have really 3 programs under EPCRS that we look at. And we kind of want to fit in the top program, and we really prefer not to be in the bottom program. So I'll start with self-correction. Self-correction is where, okay, we discovered a failure, and we're just going to self-correct. It's generally only available for operational failures. There's very specific possibilities to use this program to amend our plan, but it's generally for operational failures where we have to maybe make a contribution to the plan or send some money out to a plan participant. Self-correction means just that. You self-correct it, you do what you need to do to make the plan proper and whole and correct, or make a plan participant proper, whole, correct, and you paper the file that you made the fix and you move on. You don't have to do anything with the IRS. You don't have to submit anything to the IRS. And that's why I say we like to be in that program, because then we don't have to worry about the back and forth with respect to the IRS. We want to make sure we correct the right way, but we don't have to deal with the formal process of getting an IRS approval and filing with them. If we can't self-correct, then we're in the voluntary correction program. That is where we have to file with the IRS. It's a very broad program that we can use for various types of failures, operational, eligibility, don't document. So it's a broad program. It requires filing with the IRS, and I'll talk about it in a little more detail in a minute. Audit cap is kind of not where you want to be. Audit cap is when you have a failure, you didn't go forward to the IRS about the failure, you weren't paying attention about the possibility of a failure, and the IRS discovers it and says, you need to fix. When you get in that situation, then you start getting into the issue of, well, what is the fee going to be? Because ultimately, you're going to have to fix, but you're going to have to pay a pretty big fee to the IRS because you didn't come forward and fix yourself. Voluntary correction program has a schedule of fees if you want to use that program, and those fees, as compared to what a fee might be in audit cap, is significantly less. So my recommendation to employers is if they discover a failure, let's look to EPCRS. Let's not close our eyes and hope that we don't have the IRS coming in and discovering it, because that'll put you in audit cap. So we decided we have a failure, then we do the analysis of whether we can use self-correction or whether we need to go through the voluntary correction program. So we've got to do the analysis of the failure, whether it is significant or insignificant. If it is insignificant, we can self-correct at any time. If it's significant, then we can only use the self-correction program if it's within basically 2+ years, within 2 and just short of 3 years. So we do the analysis of whether it's significant or not. Well, you know, what things do we need to think about? Well, there's a whole laundry list of things that EPCRS talks about when it comes to whether or not something's insignificant or significant. So things like, how many failures are there? What is the plan assets that's involved? How many plan participants are affected by it? How long has the failure been going on? What's the reason for the failure? And if you can go through that list and say, yeah, you know, it's only one person, it's only 2 people, you know, it's only been a year or 2 or 3, you know, we're only talking about a couple $1,000, you know, we did a self-audit and we discovered it, then, you know, I think you're in a pretty good position to say, you know what, insignificant, we can self-correct it. So if it's within, you know, a couple of years, no matter what, you can self-correct. If it's 4 years, I would say you can still self-correct because it's insignificant. Now, if you're talking about something that happened 4 years ago, affects 20% of the participants in your plan, affects 30% of the plan assets in the plan, yeah, that's going to be significant. And, you know, you need to treat it as a significant failure. If it's beyond those few years, you're going to strongly want to consider going into VCP. When we have VCP, you know, there's a few things we need to think about. First of all, like I said before, there's a fixed fee to get that IRS approval, to submit it to the IRS. It's based on how many plan participants you have, and like I said before, if you compare those numbers to what the fees would be if you're stuck in audit cap, you're definitely in a better place doing a VCP. VCP Considerations, Form 8950, 8951. In the past, we didn't have actual forms. You just submitted a letter, you described, you know, what the failure is, what you're going to do to correct, what you're going to do going forward to make sure things didn't happen, and you moved on. Now there's actual forms that you fill out, and not only do you have these IRS forms, but you also have model compliance statements and schedules that you can submit depending on what kind of failure you have. The last item is that I note is anonymous submission. So there's a John Doe, there's an anonymous submission procedure. So if you've got something that you may think is a huge failure, and you may think, well, we want to take this aggressive position on it, but yeah, we don't really want the IRS to know it's us. There's a procedure where you can file anonymously, see if the IRS would bless it, and if they bless it, you say, oh, it's me, here I am, company XYZ. If the IRS says no, you can say, you can have your advisor pull it, and the IRS doesn't know, and then you can move forward. There's costs associated with putting it together, but you know, for those big failures or for those aggressive correction proposals, it's a program to think about. All right, so here's my list of top 10 failures because, you know, unfortunately, some of you may be sitting here thinking, oh, you need to think about this. First is pretty simple. It's making sure your plan document has been updated to reflect changes in law. There hasn't been a whole lot of these legally required amendments that need to be done recently, but, you know, if you've missed something a few years ago or 10 years ago, this is something you need to think about for EPCRS. Failure to follow plan terms. So plan document says ABC, operationally, we do XYZ. This is one, from my perspective as a consultant, as an attorney, this is where I see it come up all the time. You know, the plan document says something, and then the benefits department, you know, operates it, and something just happens. Something slips through the cracks, and we just don't operate the plan in accordance with what it says. You know, my recommendation here is look at EPCRS. If it's something small, look to self-correction. I also recommend, you know, you need to consider auditing plan document in operation just to make sure they're in sync. If you haven't done that in a few years and there's been some changes to your benefit plan, I would consider, you know, reaching out to your advisor and doing an audit. Definition of compensation. This is a big one. This is on the IRS's list when they come in and audit a plan, when they review a plan. Definition of compensation is a big deal, and it's missed all the time. You know, I had an employer where they had a simple exclusion from compensation under their 401k plan. You know, one specific type of compensation was excluded from the definition of compensation. It effectively created a more than 7-figure compliance issue. So you need to make sure that that definition of compensation is correct. 4, making sure employer contributions are properly made. 5, non-discrimination testing failures. These are something that, you know, you need to keep your eye on. You know, the last 5, you know, these are pretty basic, making sure that eligible employees who should be in the plan are in the plan, and folks who are not supposed to be in the plan are not in the plan. If you've got either of those, you need to consider a fix. You know, we've got plan limits, we've got plan loan requirements, we've got hardship distribution requirements, we have top-heavy requirements. Making sure those are satisfied. If they're not, we have EPCRS. All right, voluntary fiduciary correction program. This applies for corrections of certain fiduciary breaches. The goal here is to get a no-action letter. You file under this program, you get a nice letter saying that the government will not take action against you. And this is important because, you know, there could be individual liability for those who are fiduciaries. So, you know, the individual benefit manager, the individual pension professional, you know, this hits home for them. Like I said, it's a discrete program. The program has 19 specific breaches and methods to correct under the program. The easy one, the simple one for them to identify is the timing of when participant contributions and loan repayments go from plan assets to the plan trust. We can talk about this in a whole lot of detail, but if you're a smaller plan, less than 100 folks, and contributions are taking 10 days, 2 weeks, a month, you may have some problems. You may want to think about this program. You also may want to think about cleaning it up. If you're a large employer, if you're Fortune 500, Fortune 1000, and it takes more than a few days to get contributions into the trust, the DOL, they may come down on you for this. So that's the most common breach I see. There's a model application. There's online calculators that you can use to correct under this program. The last one, since we're running out of time, we'll go through somewhat quickly, is the Delinquent Filer Program, Form 5500s. So why is this an issue? Well, you know, it's usually not an issue for our tax qualified plans, but the issue I see is welfare plans. Whether it's the small employer who, you know, they had 50 plan participants and then they went up to 90, and then, you know, business was great and they got up to 150. Then they realized that, well, they didn't file Form 5500s. Or it's the employer who doesn't realize that welfare plans are subject to Form 5500 filings. The general rule is that if your welfare plan has 100 or more participants, you need to be filing Form 5500s for those plans. So every year for, you know, 3 or 4 clients, we file under this program. And, you know, it's a very valuable program because when you look at the costs, you know, we're talking a few $1,000s to file. If you've missed multiple years of filings for a welfare plan, you could be looking at penalties in the 6 figures. So, again, make sure that you're filing your Form 5500s for your welfare plans and for your retirement plans. So, let us do real quick, because I know we're pushing our time, 2 real quick examples. So this is an example with respect to delinquent employee deferrals. I'm proud of this example because I wrote it in the beginning of 2014 when a certain basketball player, to remain nameless, played for the Miami Heat. So we've got LeBron. He returned to Cavs Code benefit manager for 2014-15 and discovered that employee deferrals were not being transferred to the 401k plan trust until 6 weeks after payroll. Is that a problem? Do we have a correction program? Well, clearly we have a problem, and yes, we do have a correction program. We have a fiduciary compliance issue because those contributions were not properly and timely contributed to the trust. This is that voluntary fiduciary correction program. We have to reimburse for the lost earnings. I noted the online calculator, and then we have to pay excise taxes on a Form 55 or 5330. And then the next example, real quick, is we improperly exclude an employee from the 401k plan. So we've got Jimmy, the HR manager of the Browns. He discovered that Bernie was eligible for the 401k plan, made an election, but the deferrals were never properly administered. Do we have a problem? Do we have a correction program? Again, the answer to that is yes. It's an operational failure. We look to EPCRS. As I said before, we think about self-correction and voluntary correction. This is a good candidate for self-correction if it's just Bernie. So we make a corrective contribution and we move forward. So with that, I want to thank you for your time. There's going to be a couple of poll questions that come up because, again, this is the first program of 2016. Here at Finley Davies, we're planning on doing additional compliance programs. This was, you know, a basic one. We'd like to get your feedback as to what you'd like us to talk about. You know, do you want to focus on pension plans, on healthcare reform, on fiduciary concerns, on executive compensation? You know, I'm just throwing things out there. Let us know what you'd like to see. If you've got any questions, please feel free to, you know, to send them to us. We got, you know, let me look at one question that we received real quick here. We've got one question that says, if you have the change of elections mid-year in the SPD, is that acceptable? So this goes back to the cafeteria plan discussion about having a plan document. Is it acceptable if you have it only in the SPD? Let me take a step back because a cafeteria plan itself is not an ERISA plan. So the issue there is making sure your cafeteria plan document, make sure you have a cafeteria plan document that says we have these change of elections and you know, these are what they are. If it's just in the welfare plan document, that's not going to be enough. So you want to make sure that's properly dealt with. You have to have a plan document for a pre-tax commuter program. That's something that I would encourage you to have. Make sure you have a proper plan document. It's 3:02, so I want to be respectful of your time, and Lisa's going to close us out. But again, I just wanted to thank you for spending the time with us, and please, you know, let us know how we did in the polling questions, and please let us know what you'd like to see us do in the future. So with that, Lisa.
Thanks, Jason. I will be sending a follow-up email to everyone with a link to the presentation as well as the recording. And at that time, we'll be asking a couple of poll questions as well. We would like to get feedback for our 2016 Finley Davies webinar series. And a reminder to those who would like the HRCI credit, you can either type your first and last name in the chat window and send that to me, or you can send an email to Lisa K, and that's LKAY@finleydavies.com. And feel free again to contact Jason to answer any specific questions you might have about the topic covered today. And thank you for joining us.